Need a couple of minutes to sort of gather
I'm
yourself?
fine. No, I'm fine. I just but I do want to be able to share a screen here in a second. So let me pull that up.
Okay, and while we're starting here, let me go ahead and introduce you, and then we'll kind of go from there if that works.
Okay, great.
Okay, yeah. So again, apologize for the delay. My name is John Foran. I'm the director of Miami University's Menard Family Center for Democracy. And on behalf of the university, it's my pleasure to welcome you to tonight's talk by Professor Michael McConnell, which is the 9th and final talk on issues of democratic governance that the Menard Family Center is presenting this spring. Professor McConnell comes to us this evening as one of the nation's most influential and distinguished experts on the history, structure, and meaning of the United States Constitution. Born in Louisville, Kentucky, Professor McConnell holds a bachelor's degree from Michigan State University and a JD from the University of Chicago. Among his many achievements and honors as a legal scholar and jurist, Professor McConnell clerked both for Judge J. Skelly Wright at the U.S. Court of Appeals for the District of Columbia Circuit and for Justice William Brennan at the U.S. Supreme Court. He's held senior positions during the Reagan administration in both the Office of Management and Budget and the Office of the Solicitor General. He's argued 16 cases before the U.S. Supreme Court, including one just a few months ago by telephone, sort of part of the COVID process we're all sort of grappling with. Within academia, he taught for over a decade at the University of Chicago Law School, and he's also held professorships at the University of Utah, Harvard, and NYU. And from 2002 to 2009, he served as a federal appeals court judge on the U.S. Court of Appeals for the 10th Circuit, appointed to the bench there by President George W. Bush and confirmed unanimously in 2002 by a democratically controlled U.S. Senate. Currently, Professor McConnell is the Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford Law School, and he's a senior fellow at the Hoover Institution. His most recent book, entitled The President Who Would Not Be King, Executive Power Under the Constitution, was published late last year by Princeton University Press, and it now stands as the definitive account of how the founders understood the institution of the American presidency that was created in Article 2. Before turning the webinar over to Professor McConnell, just a couple of quick housekeeping items. First of all, we would encourage you to submit questions during the talk, and because we're on Zoom, if you could do that through the Q&A function on the Zoom webinar here, that'd be great, and then we can look at those questions when he's done with his presentation. And also, we have closed captioning available. If you would like to take advantage of that, it should be at the bottom of your screen there. So without further ado, let me turn it over to Professor McConnell. Thank you very much for coming. And did you figure out sort of the sharing the screen part?
So thank you, and thank you all for attending tonight. And please accept my apologies for my being late. I have no good reason, I have no good excuse. I do actually have a reason, which is I was just teaching my class over Zoom at from Stanford Law School, and I go to a place with stronger internet for doing that, and I had intended just to stay there and do this program, but at the end, habit took over, and I don't know if you ever do this, but I just did what I always do, piled out and drove home. And then when I got here, I immediately realized I had stood you up, which I didn't mean to do. But I'm going to be talking about the presidency, but not from the point of view of a political scientist or a news junkie. I'm not going to be talking about Joe Biden and Donald Trump and so forth. I'm going to talk about how the framers of the US Constitution envisioned the presidency and how they put it together. And it was one of the hardest tasks for the Constitutional Convention delegates. Very hard task for a number of reasons. Most importantly, no one had ever done such a thing before. They were they had no models to pattern the American presidency after. They didn't want a king. In fact, that's the title of my book, is The President Who Would Not Be King. They did not want to recreate King George III, or worse yet, the colonial governors, who were even more oppressive and unreasonable and arbitrary and self-dealing than the king was in his own domain at home. And there had never been a strong, independent, vigorous, powerful Republican executive. And Republican theory, that is the dominant political theory of the day, tended to teach that it was not possible, that a strong executive was in some sense in tension with the principles of republicanism. And so they had worked all this out for themselves. And and to make things even worse, James Madison, who was the principal architect of the first draft of the Constitution, we'll talk about that in a moment, was a real child of the legislature and had no intuitive sense of what a Republican executive would look like. He wrote a letter just before leaving for Philadelphia. He wrote a letter to George Washington outlining all kinds of ideas that he had for the new Constitution. But on the subject of the executive, he said that he had scarcely contemplated either what the powers with which it would be clothed or the manner in which it would be constituted. So it was of all the subjects before the delegates, their principal or theorist, James Madison, was kind of AWOL on the question of the executive, although he jumped into it during the summer. So it was a very difficult task. And let me share with you a screen here that will help, that I'll just want to discuss or talk to you about how the executive developed in Philadelphia in 1787. And then we might want to talk about the implications of that, or some of the implications of that for today. But so the convention begins with the presentation of the Virginia Plan, and this is from Madison's notes of June 1st, and he says, or I'm sorry, of May 30th, and he says, it says, Mr. Randolph, one of the deputies of Virginia, laid before the House for their consideration sundry propositions in writing concerning the American Confederation and the establishment of a national government. So Randolph presented the plan, but the real author of the plan was James Madison. He didn't write the whole thing. Some of it, he didn't quite get exactly what he wanted on every point, but most people are, most historians are persuaded that he wrote most of it, and that Randolph, who was the governor of Virginia at the time, and who was a much more charismatic figure, much stronger speaker, young, handsome, could command a room, that he presented the plan. Madison himself was unusually short and had quite a high, weak, reedy voice that sometimes made it difficult even to hear him. But so Randolph presented the plan, and his name is associated with it. And Resolution 7 of the Virginia Plan is the part having to do with the executive branch, and it resolves that a national executive be instituted. This in itself is a change, because the government under the Articles of Confederation did not have an executive branch. That it be instituted, that in addition to a general authority to execute the laws, it ought to enjoy the executive rights vested in Congress by the Confederation. This is so sketchy. I mean, it barely, even touches the surface of what you would want to know about an executive, but it wasn't without content. And immediately, next thing that happened, before there was anything else, young Charles Pinckney, he was the second youngest delegate and at the convention. He's from South Carolina, and he's the first to speak. And he says he was afraid those executive powers, is just based on the language you just saw, that they might extend to peace and war, etc., which would render the executive a monarchy. Now that's interesting. Throughout the summer, and then especially during the ratification debates, one of the serious concerns was whether a strong independent president who had command over the military forces might be able to pull a Julius Caesar or an Oliver Cromwell and make himself essentially a military dictator. And it's interesting that before they got into any details at all, that Charles Pinckney was worried that the Virginia plan would give the executive the powers of peace and war, which now, why would he think that? Again, here's the language. In addition to a general authority to execute the laws, the executive ought to enjoy the executive rights that were vested in Congress by the Confederation. So this means the executive powers exercised by the Congress under the Articles of Confederation. So these are, note that there are two different things here. The general authority to execute the laws was new. One of the real defects in the national government under the Articles of Confederation was a lack of any executive authority. The Congress would pass things, and essentially like taxes, for example, and the states had to carry them out. And this new Constitution would provide for execution of the laws by the national government in the form of the executive branch. And these executive rights vested in Congress by the Confederation. What are they? Well, we have to look to the Articles of Confederation to see what they were. And here's a list. These are all powers. If you read a copy of the Articles of Confederation, you'll see that all of these powers were given to the Congress. Determining on peace and war. That's where Charles Pinckney got his language for his complaint. Sending and receiving ambassadors, entering into treaties and alliances, regulating captures and prizes. That's where ships were captured or on the high seas in times of war, or other captures in times of war. Granting letters of mark and reprisal, determining the value of coins, standards of weights and measures, dealing with the Indian tribes, establishing post offices, appointing and commissioning Army and Navy officers, and directing the operations of the land and naval forces. Now, how do we know those are executive? If you look at the Articles of Confederation, there's no heading there. It doesn't say executive powers. It's just that, and there are a lot of other powers vested in the Congress too. Why are those executive? Well, the answer is that they were the powers held by King George III. Even as of 1787, the British Constitution was in the process of being transformed into a constitutional monarchy with parliamentary supremacy, and basically Parliament decides everything, but they weren't all the way there yet. And as of 1787, King George still had the unilateral power. He didn't have to go to Parliament first, or he had the unilateral power to take the nation into war and to negotiate peace and all those other things on the list. These are called prerogative powers. This is a term we use a little bit in US constitutional law, but it's a major concept in British constitutional law even now. A prerogative power is a power which is vested in the officer by virtue of his office and not delegated by the legislature. And it's a matter of basically the executive has discretion discretion to determine both policy and the means of carrying the policy out. And at least in theory, Parliament or the legislature or the Congress can't interfere. Now, actually, there are lots of ways they can interfere by denying funding and so forth, but they can't directly interfere because these powers are vested in the executive by virtue of the Constitution. Clear examples from the US Constitution that you'd all be familiar with are the pardon power is a prerogative power of the president. He gets it straight from the Constitution, and Congress doesn't have anything to do with it. The veto power is another prerogative power vested in the president by the Constitution. But at the time, and back in 1787, there were quite a lot of these still held by King George III. They were vested in the Congress under the Articles of Confederation. But now the Virginia Plan says that that they would all be vested in the new executive. And that was not a happy thought, because if we have an executive who exercises the prerogative powers of the King of England, that effectively, what's the difference? That makes him like the king, makes him a monarch, albeit an elective one. But that was not what many of the delegates had any intention of creating. So that's the origin and explanation for Mr. Pinckney's remark. And when he makes this remark, I think this is one of the more dramatic moments at the entire convention, because Madison reports that a considerable pause ensued. It's the only time all summer long that there is such a pause. Usually there are numerous delegates all sort of jockeying to speak. They don't have any shortage of comments on whatever the subject is of the day. But on this one, they were silent. Now, why would that be? Well, maybe partly because the topic was very difficult and important and non-obvious. The solution was not obvious. But I think there's also a psychological reason here on top of that, which is that George Washington was sitting right there. In fact, he had been elected the chair of the Constitutional Convention. And so he's sitting right there, and everybody knows that he's going to be the first president of the United States. So how do you discuss the possibilities of tyranny and abuse of power when the person who's going to be exercising the office, the most trusted man in America, is sitting right there? Well, we then hear some comments. John Rutledge from South Carolina was almost certainly the most experienced executive in the room, sort of James Madison's polar opposite. Rutledge had been governor of South Carolina during the British occupation, which was extremely harsh. You may have seen the movie The Patriot, which is not accurate in a whole lot of respects, but it does show and it does accurately depict just how brutal the British invasion was. And it was too dangerous for the legislatures or the courts to meet. So the legislature vested Rutledge with all the powers of government. So he had he could pass laws, he could execute them, he was basically the government. They called him a dictator, meaning meaning the combination of legislative and executive power. And he basically held things together. He was probably the most effective wartime governor under just extraordinarily difficult circumstances. And so when he spoke at the Constitutional Convention about the nature of the executive, people listened. And especially because then at the end of the war, he laid down all those powers and became a judge for the rest of his career. And so and a walking illustration that you can be an all-powerful executive and in a time of an emergency and not necessarily turn yourself into a tyrant. So he said he favored a single executive, but was not for giving him the power of war and peace. James Wilson of Pennsylvania, the best lawyer among the delegates at the Philadelphia Convention, said that he did not consider the prerogatives of the British monarch as a proper guide in defining the executive powers. So he doesn't want to give the new executive all these royal prerogatives. Instead, they're going to think about them one by one and allocate them. Now, Madison had a different idea. He proposed letting Congress decide which prerogative powers would be given to the president and which would not. That was voted down. So that would have, if that had prevailed, instead of having constitutional powers vested in the president, Congress would be able to decide. It would be a considerably more powerful Congress if that were true. Well, still jittery as a result of Mr. Pinckney's prescient comment, the delegates on June 4th, this is just what, 1 week into the convention, vote to create a presidency of a single person, but with very few powers. Power to carry into execution the national laws, to make some appointments, but not some of the most important. The president would not nominate judges, would not nominate ambassadors. Those functions would be devolved upon the Senate instead of the president, and he would have a veto subject to override. So that was the way things were. That's the way things stood all the way until the middle last part of July. And in the meantime, the convention almost fell completely apart because of the conflict between the large states and the small states and the principle of representation in the two houses of Congress. But once that was compromised, what we call the Connecticut Compromise, with the lower house proportional to population and the upper house with the states equally represented, they then sent all the votes that had been taken to the Committee of Detail. This is the biggest misnomer of a group, I think, in the entire founding period. Detail. I think a lot of people did think what they were going to do is just sort of put it together and work out, minor points. But the Committee of Detail, which was chaired by John Rutledge and on which James Wilson sat, along with Edmund Randolph, and the other two were no slouches. Nathaniel Gorham of Massachusetts had been the chair of the Committee of the Whole, so he was one of the leading framers for the first half of the summer. Oliver Ellsworth from Connecticut is responsible in large part for the Connecticut Compromise, and later would be Justice of the Supreme Court, as would actually three of these five gentlemen would go to the Supreme Court in the early days of the Republic. This committee, far from sticking to detail, was audacious. They not only did they do things that the convention had not voted on or even considered before, but in some cases, they did things that the convention had actually rejected. the enumeration of powers of the national government, for example, that idea had been voted down. John Rutledge had made a motion to enumerate the powers, and that was voted down. He then becomes chair of the Committee of Detail, and lo and behold, the committee decides to enumerate the powers of the national government, the powers of Congress in Article 1, Section 8. But for our purposes, what's most interesting is how they constructed the powers of the executive. And this is my theory. Not everybody agrees with it, and you may not agree with it, but my theory is that the Committee of Detail was operating with a mental list, maybe even a written list, maybe even the book, but a mental list probably of the prerogative powers of the king as of 1787. And they get the list from William Blackstone's Commentaries on the Laws of England, in which, depending on how you count them, Blackstone lists roughly 42 different prerogative powers pertaining to the crown. And the Committee of Detail allocates those in two different ways. Allocates some of them to Congress and some of them to the president. And then some of them are denied to the new national government altogether. So, for example, the king was the head of the Church of England. Well, we weren't going to have an established church, so that was denied to anybody in the new government. Congress receives, look at this list, gets a number of these royal powers. So instead of vesting all of the powers of an executive nature in the executive, the Committee of Detail parcels them out. That's exactly what Wilson had suggested on the first day of debate about all of this, not to let the prerogatives of the king necessarily dominate. So they think about each one and figure out which ones they think are safely vested in the president and which ones are better vested in Congress. Then they vest some of them in the president, and some of them they recast as duties rather than mere powers. The most important one of the duties being the duty to take care that the laws be faithfully executed. So the president doesn't just have the power to execute the laws, the president has a duty to execute the laws. Unless Congress has abrogated the law or authorized the president to waive sections of the law, the president of the United States does not have authority to decide not that he simply disagrees with the law and he's not going to carry it out. Several of our recent presidents have brushed up against that principle. By brushed up, I mean, seemingly violated it. And then a number of the powers go directly to the president, some of them subject to the advice and consent of the Senate. Now, interestingly, even the prerogative powers that are given to the president were rewritten, reduced in scope, so that if you compare Blackstone's account of them with what the Constitution provides, the president is less powerful than the king. The commander-in-chief clause is a great example of this, because the king was the commander-in-chief of all of the armed forces of the kingdom, including Army, Navy, and the militia. The militia was very important part of the armed forces in the 18th century. It was the Army was a professional career standing army, but the militia was made up of part-timers, people who had other lives. They're farmers and shopkeepers and whatnot, who would be called into service when they were needed. militias were thought to be much safer for the liberties of the people because they were the people. You didn't have this danger of a sort of professional and force being battened down on the country in the service of the commander. Instead, these were citizen troops and therefore thought to be much more much less dangerous. Well, the king was commander-in-chief of all of them, but the president is commander-in-chief only of the Army and Navy and of the militia of the several states when called into the actual service of the United States. The militias were actually arms of the state governments. They were raised by the states. They were armed by the states. They were trained by the states with some congressional authority over that. And their officers were chosen by the states. Well, what did this mean? That meant that the president did not have command over all of the armed forces during peacetime, or even actually sometimes during war. And I say he didn't have power over all of them. The militia was much larger than the standing army. Under Washington, the standing army never got to be over about 1,000 men, most of whom were stationed on the frontier. Meanwhile, there were tens of thousands of trained militia soldiers under their own state-chosen officers. Well, what does that mean? That makes it virtually impossible for the president of the United States to have a military coup and to take over. So we would not have a Napoleon. We would not have a Julius Caesar. This was an ingenious solution to the problem of needing a commander-in-chief, but not trusting anyone with that kind of power. The pardon power was also limited vis-a-vis the powers of the king. Not only could the president not grant pardons in cases of impeachment, so if he and his cronies were the subject of an impeachment proceeding, there wasn't anything that he could do to prevent that from taking place. But perhaps more importantly, offenses, he could grant pardons and reprieves only for offenses against the United States. And the vast majority of crimes are crimes under state law. Even today, I think something like 95% of the criminal prosecutions are for violations of state law, not federal law. And it was even more extreme back then. In the first Congress passed a small handful of criminal acts. And so whereas the king could pardon anyone for any crime, since all crimes in Great Britain were national in nature and prosecuted in the name of the king, the president's pardon power was much reduced compared to that. And appointments and treaties were made subject to senatorial advice and consent. And over in Britain, these were unilateral powers of the crown. Now, at this point, which is the Committee of Detail, the primary foreign affairs powers were not yet vested in the president. The Senate had the power to send ambassadors and to make treaties, as well as to appoint justices of the Supreme Court. But those powers were later transferred to the president, subject to senatorial advice and consent. That happened in very late August and early September. Now, here's a very important additional aspect of the powers of the president that was done by the Committee of Detail. After having parceled out, all of the powers of the prerogative powers of the king, which meant all the important powers, the big things, they were aware of the fact that there were a number of sort of second order prerogatives that were not mentioned in Blackstone and were, you know, but nonetheless would come up in practice. And so they added an executive power clause vesting the executive power in the president. When it did that, it did not mean that the president had all powers of an executive nature. We just saw that a number of executive powers are vested in Congress. Congress gets those. What this means, though, is if there is an unenumerated power of an executive nature that has not been vested, either vested in Congress, denied the federal government altogether, or reduced in scope, that would pertain to the president. The practical consequence of that is that these executive powers are vested in the president, but if the Congress has an enumerated power that bears upon it, and they subsequently pass a statute, that Congress, not the president, ends up trumping with respect to these powers. Here's what the vesting clause says. The executive power shall be vested in a president of the United States of America. And then we have, I'm just giving you here a review of the scope of the president's powers. So you have the vesting clause, then Article 2 lists the prerogative powers of the president. Article 2, Section 2, or the prerogative powers subject to advice and consent. And Article 2, Section 3 lists the duties of the president. And then the most controversial part of all of this is the vesting clause. And there are, scholars today divide very much on this, just as they have, for 235 some odd years. So I'm presenting you my interpretation of the vesting clause, but there are other possible views as well. So this is what it says, but then the question is, what does it mean? The substantive interpretation is that the clause vests unallocated powers of an executive nature in the president. And then the nominal interpretation is that all that the vesting clause does is it prescribes the number, namely 1, and the title, the president of the executive, but his powers are solely those listed in sections 2 and 3. And this is one of the most important separation of powers questions, because Article 2, sections 2 and 3 don't spell out everything. There are lots and lots of important gaps. Who sets foreign policy? Who supervises the bureaucracy? Who controls immigration and foreign travel? Who interprets law until it's decided by courts? Who gets to fire officers like, say, the director of the FBI? Who's entitled to receive and reveal top secret information? And there are just numerous other questions of this sort. One of the main reasons to think that the vesting clause of Article 2 of the president is substantive rather than nominal in nature is to compare the 3 vesting clauses of Articles 1, 2, and 3. Article 1 says all legislative powers herein granted shall be vested in a Congress of the United States, but Article 2 conspicuously says the executive power shall be vested. It doesn't say the powers herein granted, but the executive power. That I think strongly implies that the Congress is limited to its enumerated powers, but the president is not, nor is the judicial branch. I think this is confirmed by the way in which the clause evolved, that under the Virginia plan, the executive, quote, ought to enjoy the executive rights vested in Congress by the Confederation. That is obviously substantive in nature. Then in June 1st revision, there's no vesting clause at all. The initial draft of the Committee of Detail phrased the vesting clause as, it didn't really have a vesting clause. What it said was the executive shall consist of a single person and his powers shall be, and then there's the list. Note that that initial draft is exactly what today is the nominal interpretation of the vesting clause. Committee of Detail then changed that to read the executive power of the United States shall be vested in a single person, and then he shall have the power too, with the list of enumerated powers. I submit to you that there is no reason to change the wording from that first initial draft to the final draft unless they intended to move from the nominal interpretation to the substantive interpretation. There also are very early interpretations by prominent figures, Madison, Hamilton, Jefferson, all three of them. So in 1789, Madison addressed the question of whether the president has an inherent power to fire the Secretary of State. Many people said no. Since the Senate has to give advice and consent to naming a person, the Senate has to give advice and consent to firing the person. But Madison reasoned the Constitution affirms that the executive power shall be vested in the president. The question now resolves itself into this: is the power of displacing, that is firing, an executive power? So that clearly indicates that Madison is subscribed to the substantive interpretation. Thomas Jefferson, too, he's addressing in his capacity as Secretary of State. The issue here is whether the president gets to designate where the titles that would pertain to foreign officers, like ambassadors and consuls and so forth. He says the transaction of business with foreign nations is executive altogether. It belongs then to the head of that department, except as to such portions of it as are specially submitted to the Senate. So powers of an executive nature that are not enumerated and also not given to Congress belong to the president. Alexander Hamilton, in his defense of Washington's neutrality proclamation, gives the fullest account of the meaning of the vesting clause. He says, the general doctrine then of our Constitution is that the executive power of the nation is vested in the president, subject only to the exceptions and qualifications which are expressed in the instrument. So the hypothesis here is that all powers of an executive nature, meaning those that are not legislative or judicial, that are not already allocated to Congress or the president, belong to the executive. And the implication is that if Congress does have an enumerated power and passes a law, this necessarily supersedes the president's residual executive power, which means that there are three types of presidential power. There are prerogative powers, which come from the Constitution and are indefeasible, meaning they cannot be taken away by Congress. There are residual powers under the vesting clause, which come from the Constitution but are defeasible if Congress has a relevant enumerated power. And then delegated powers, which are powers that come from the Congress. And so this is my sketch of the basic architecture of Article 2. We could talk about examples or whatever, but I think I'm going to stop now and see if any of you have comments, questions, or points that you'd like to discuss.
Thank you very much. Yeah, and yeah, thank you've given us a lot to sort of chew on there. And we have had questions coming in. Do you have time for 3 or 4 questions?
I do, and since I arrived late, I'm not going to leave early. So how
Oh,
much
thanks.
time?
Well,
But I don't want to be a burden on their patient.
oh, not at all. Well, we've had a couple questions. Let me sort of combine the questions, actually. The A couple of people have asked basically about, in light of your work on the history of Article 2, the history of the development of the presidency, basically, what was your reaction to the 2 impeachments of President Trump? If you could imagine, what would the framers have thought? Would it be consistent with their expectations, or do you have any thoughts on that?
So I have a chapter in the book about impeachment and talk about both of, actually, I only talk about the first Trump impeachment because the second one hadn't taken place yet. And so for one observation, which isn't just about the Trump impeachment, but I think is a real problem with the Constitution, is that they made it possible you impeach by majority vote of the House, but only convict by 2/3 vote of the Senate. And when you look at this, there's no clear reason why they did it that way. I'm sure that the reason for the 2/3 requirement is that they did not want presidents removed too easily. They didn't want impeachment to serve as a kind of vote of no confidence. But why the difference between the House and the Senate? Because the effect of this is to put the country through the ordeal of impeachments relatively easily, but without the benefit of getting rid of the bad presidents at the other end. It's like we go through these traumatic experiences like the Bill Clinton impeachment, and to no avail. I think we should have a higher threshold for impeaching and maybe a lower threshold for convicting, and that might be better. Then I talk a good bit about how the high crimes and misdemeanors standard came to be, the substantive standard. Talk about the claim made by Mr. Trump's lawyers, including Harvard law professor Alan Dershowitz, that only actual crimes can be the basis for an impeachment. That is not a frivolous argument. There is a lot to it, but I think it's wrong on balance. I think when you look at the evidence as a whole, that serious misconduct is impeachable. In the first Trump impeachment, there were 2 articles of impeachment. One of them had to do with his his use of the powers of the office to try to provoke an official investigation, or even actually what he asked for was the announcement of an investigation of his likely political opponent in the next election by the Republic of the Ukraine. And I believe that was an impeachable offense. I think that Trump threatened to do something he did not have the power to do, which was withhold an appropriation made by Congress. And I think that is for an improper purpose, that is to get another country to investigate his political opponent. If he thought, as he probably did in good faith, that the Hunter Biden affair was corrupt and that it needed investigation, he should have, quietly gone to the Justice Department and expressed his view, as he has every right to do, that there should be an investigation. The investigation should then have gone on, quietly, without public announcement, and with professional prosecutors and based upon actual evidence, rather than a foreign nation that was beholden to Mr. Trump, and asking for a formal announcement of the investigation before anything ever took place. So I think that's impeachable. Now, senators, that doesn't mean senators had to vote to convict and remove on that ground. Other presidents have done things that are worse. And to some extent, this is a matter of judgment for the Senate. I think less on whether he was guilty than on whether the charge in context was sufficiently serious to warrant unseating someone who had been elected through proper means to the presidency. And that's, I think, a question for each individual senator to determine. The second article of impeachment had to do with his ordering or asking various executive officials not to present evidence to the House committee that would later vote the article of impeachment. I think this was an improper article because I think President Trump did nothing that was not within his authority, that an invocation of executive privilege is not an impeachable offense. And what's more, the House behaved and they acted in a procedurally improper fashion, that they conducted these hearings before they initiated an impeachment proceeding by vote. Now, Nancy Pelosi announced in a press release that they were going to be having an impeachment proceeding, but it requires a vote. There has always been, impeachments are always, both in America and prior to that in Britain, initiated by a resolution of impeachment, which then empowers the appropriate committee to obtain the necessary documents from the executive branch. They did it the other way around, and I think President Trump was quite entitled to resist those efforts, and therefore I think the second article of impeachment was improper. Now, I didn't write in the book about the second impeachment, but I think it's much clearer that that is within the ballpark of impeachability. The big issue there was timing, and many of President Trump's defenders argued that the Senate could not take up the impeachment matter because he was an ex-president by then. It is my reading of the relevant clauses that the House may not impeach an ex-president, that the impeachment proceeding has to be before the president leaves office, but that this trial in the Senate does not, that the Senate has the power to try any impeachment, including those where the president is no longer in office, and the Constitution expressly gives the Senate the authority to invoke the sanction of disqualification from future office. So it makes perfectly good sense for the Senate to be able to take up an impeachment if the impeachment itself was timely, that the Senate's decision as to what to do about it is timely.
Thank you. We've been getting some terrific questions in sort of circling around the idea of the role of history or the use of history in constitutional interpretation. And again, I'll kind of combine several questions and put it this way, I guess. So your latest book, a lot of your work with religious liberty, among other issues, relies very heavily on sort of trying to discover and reconstruct, in some sense, what the framers of a passage may have been thinking or may have intended, that kind of thing. That's controversial in some circles. So I guess could you talk a little bit about what you see as the appropriate use of history in constitutional interpretation?
Well, it is controversial. although I don't think it's controversial that that is an appropriate starting point. There are those who think that we are not bound by the text and history, and that may be so. But I think before we decide that we should do something else, we should figure out what the Constitution actually means. And there are really two reasons why that makes sense to me. One is that, I think it's the natural way of reading any document, which is, which expresses, intentions for the future. Is you look at the words and then you read them in the context of what the project was. So I think this is the way we read contracts. This is the way we read most documents, private documents, as well as public documents. Now, I am not a big fan of looking, at every bit of the legislative history, which often is divided. I think the most valuable form of history is to see where a particular clause or idea comes from, what before it ever comes into the room, before they ever adopt it. What was the historical experience that the American people had with that idea. And I think that's the best clue to what it means. Now, so I think it's just the natural way of reading a document. But there's a practical reason too, which is that we need, Americans disagree about a lot of things, and including the meaning, what presidents should be able to do and so forth. And if we don't take our bearings from something that's common to us, namely the history and the text, what is going to be the basis for decision making? I think we will just end up recreating in the courtroom the same political and ideological and partisan divisions, that we have outside of the courtroom, but now it'll be the judges who are the politicians and instead of the legislators. Whereas it is, my experience, as a judge and as a constitutional law professor and a student of this sort of thing, that the text and history actually bring people together, that judges do sometimes, not always, but they do sometimes subordinate their partisan ideological views when they see that the text and history point the other direction. And I think that's a valuable thing that we should not cast aside just in order to get one or two cases decided the way we might want them to be decided.
Thank you. And thank you very much for sharing your time with us. Let me, as a final question, ask something that has come in that's entirely unrelated to presidential authority at all, but is asking about basically your experience of going through the confirmation process for a federal judgeship. And in light of that experience, do you have any thoughts about how the confirmation process has evolved politically since then? And the question that mentioned this pointed out, you were confirmed unanimously, and this is not often the case now. Do you have any thoughts or concerns or anything about that?
Well, the system is not working as it should. I was in the end confirmed by unanimous consent. That is sort of unanimous, but that means I got one vote. Actually, there was no one else on the floor. Unanimous consent means anybody could have come and objected, but they didn't. But it wasn't easy when I was delayed 19 months before I ever got my hearing. I was declared by the other party as one of the four most controversial of President Bush's appointees, and most of them did not get through. Right up until my hearing, I was learning from my friends on the other side that I was probably not going to be confirmed. I had a tumultuous, like 8 or 9 hour hearing, and I did something that is a little scary, which is I did not follow the advice of my White House handlers, who always say, "Don't say anything." They say, "Just say, don't, that might come before me as a judge, and just keep your head down." And I didn't think that was going to work for me. I had written on almost every controversial topic of constitutional law, and I didn't think keeping my head down was a good idea. And so I answered all of their questions but one, and that one was something that I knew really was very likely to come before the court I was being named to. And I had arguments with a number of the senators, but by the end of the day, I think they were persuaded that that I was not some evil partisan extremist, that I had reasons for what I said, even if they wouldn't necessarily agree with them. And so I then passed out of the committee with only 3 negative votes, and then they chose not to fight about it for the final confirmation. The partisanship that we now see is not good for the country. Under Mr. Trump, excellent nominees were often, they had trouble getting any votes from Democrats. We haven't seen much under Biden yet, but I predict that unless things get much better, that even very good nominees are not going to get more than a handful of Republican votes. This is a relatively new thing. I think it began toward the end of the Obama administration. And it was not always that way. I mean, it used to be that nominees who had good records of public service and whose views were within the political mainstream, they might be roughed up a little bit in the hearing, and every so often 1 or 2 of them would be sacrificed on the altar of partisanship. But for the most part, they would get through. And I think that's one of the reasons why the American judiciary is as strong as it is because presidents of both parties are able to name the best people to the courts. And so we have very distinguished progressives, we have very distinguished conservatives. That's the kind of judiciary I think that a diverse nation like ours should have.
Thank you. That's I think a great point to close on. Let me thank you for joining us tonight and sharing your time and expertise with us. I really appreciate that. I also want to thank those of you who have tuned in to watch tonight, students, faculty, as well as community members and others. And thank you for your questions that you submitted as well. And let me also say that tonight concludes our spring series of dialogues on democracy. And so we will have another series in the fall. So please watch out for emails about that, and we'd love to have you join us again. So with that said, thank you again, Professor McConnell, really appreciate it. And everyone have a pleasant evening.
Night.
Thank you.